This is Barry Zalma on insurance. Today I'd like to talk about the ethical obligations of independent medical examiners. Many times in the investigation of an automobile liability or other liability claim where a person claims bodily injuries, it is worthwhile for the insurer to retain the services of an independent medical examiner to determine if and to what extent the person was injured. Medical examiners have established their own codes of ethics with regard to an independent medical examination, and are obligated by those codes to report their findings fairly and accurately. The American Board of Independent Medical Examiners has published the following Code of Ethics. Physicians shall be honest in all communications, respect the rights of the examinees and other participants, and treat these individuals with dignity and respect. At the medical examination, the physician should introduce himself or herself to the examinee as the examining physician. Advise the examinee that they are seeing him/her for an independent medical examination, and the information provided will be used in the assessment and presentation in a report. They will provide the examinee with the name of the party requesting the examination, such as ABC Insurance Company. Advise the examinee that no treating physician-patient relationship will be established. Explain the examination procedure. Provide adequate draping and privacy if the examinee needs to remove clothing for the examination. Refrain from derogatory comments, and close the examination by telling the examinee that the examination is over, and ask if there is further information the examinee would like to reach conclusions that are based on facts and sound medical knowledge, and for which the independent medical examiner has adequate qualifications to address. The examining physician must be prepared to address conflict in a professional and constructive manner, never accept a fee for services which is dependent upon writing a report favorable to the referral service, and maintain confidentiality consistent with the applicable legal jurisdiction. An independent medical examiner has a contractual relationship with the entity that employs them, but no pre-existing relationship with the subject of the examination, and this contractual relationship is often independent of, if not adverse to, the subject's relationship with the examiner's employer. To impose a categorical duty of care running from the independent medical examiner to the subject would put an examiner in an untenable position, if not an outright conflict of interest. Consider Kirk versus Anderson, a 2021 decision of the Utah Supreme Court. The adjuster, or defense lawyer, who follows the rules profiled by the American Board of Independent Medical Examiners, which are similar to those posited by the International Association of Special Investigation Units, should receive appropriate independent medical advice. The adjuster, the lawyer, and the SIU fraud examiner must be dedicated to promoting a coordinated effort within the industry to combat insurance fraud, providing education and training for insurance investigators, developing greater awareness of the insurance fraud problem, encouraging high professional standards of conduct among insurance investigators, and supporting legislation that acts as a deterrent to the crime of insurance fraud. When an IME, an independent medical examiner, is retained, the insurer should advise the IME of his obligations in writing in the following manner. Quote, "You have been retained by the ABC Insurance Company to conduct an independent medical examination of the claimant and report to me concerning the injuries sustained, the present condition, your prognosis, and your evaluation of any continuing treatment needed by the claimant. To assist you in that regard, we enclose as complete as possible all of the medical records of the claimant of which we are aware. The purpose of your examination is to thoroughly review all relevant facts within your field of expertise so we may determine whether the injuries reported by the claimant captioned above was caused by the accident, and if so, the extent of the injuries, so that we may properly evaluate his claim against our insured. We expect your examination to provide the company with sufficient facts to assist it in its obligation to make a decision with regard to the claim. The company intends to deal fairly and in good faith with its insured and the claimant, and has therefore retained you to thoroughly examine the claimant so that the company may discover the extent of its obligations. We therefore request that you complete your examination as soon as possible within the confines of your professional responsibility and report to me the following. 1. The current condition of the claimant. 2. The cause, if available, of the injuries or illnesses claimed. 3. The treatment necessary to resolve the injuries. 4. Whether a full recovery is possible. 5. Whether the claimant has any permanent disability. 6. Whether the claimant can perform the normal duties of his profession, and if not, your prognosis, when the claimant will be able to return to work. Whether the claimant can perform the duties of any profession, and if not, your prognosis when the claimant will be able to do any type of work. And 8, your best estimate of the cost of future medical treatment you believe is necessary to allow the claimant to recover. The adjuster dealing with an IME should never, under any circumstances, instruct an IME what findings the insurer requires, conceal from the IME any information the insurer possesses that might affect the IME report, misrepresent to the IME any facts, advise the IME that the adjuster suspects fraud, fail to provide the IME with all available medical records of the claimant or insured, obtain the reports of more than one IME if the first report does not support a finding of fraud, or use only one IME for all independent medical examinations. The ethical adjuster who needs an IME to properly evaluate a claim will always, 1. Retain the services of an IME in writing. 2. Use in the course of his or her professional life multiple IME physicians and chiropractors who have proved that they follow the ethical obligations of members of the American Board of Independent Medical Examiners, even if they are not members themselves. And 3. Provide all available medical records to the IME. When dealing with an IME, it is essential that the defense lawyer or the adjuster or SIU investigator remember that insurance is a business of the utmost good faith. The IME is only a tool that the ethical adjuster must never abuse. Although insurers are frequent victims of fraud, they must treat everyone they come in contact with as honest until proven by a preponderance of the available evidence to be a fraud. The purpose of the IME is to verify the extent of injury, not to establish fraud. If the extent of injury found by the IME is different from that presented in a claim, the SIU or independent counsel should be contacted to evaluate the results of the IME and determine if a fraud investigation is warranted. The American Medical Association Code of Medical Evidence provides that despite an IME physician's ties to a third party, a limited patient relationship should be considered to exist between an IME physician and the examinee. Review of the docket of plaintiff's employment discrimination case in the Eastern District of California revealed that the court ordered the IME. Specifically, the court order provided that plaintiff shall appear for an independent medical examination by Dr. Mark Mills, MD, at a specific date, time, and place. Moreover, once the plaintiff balked at attending the IME, plaintiff's allegation that the defendant's conduct caused her numerous physical and mental health-related injuries put her mental state genuinely in controversy. This is Bell versus United States, a 2018 decision of the District Columbia. Now, the adjuster, of course, before the IME, should obtain the medical records with an authorization signed by the claimant and should visit the medical facility in person to verify its existence as a functioning healthcare provider. If the adjuster believes an independent medical examination is required, he or she should insist that the medical examiner be truly independent and have all medical records available for review. Most insureds and their attorneys believe independent medical examiners are not independent, but are owned by the insurer. This is simply not true. The adjuster should never, ever attempt to change the opinion of the independent medical examiner, even if it is contrary to the interest of the insured and the insurer. If the IME retained is capable and honorable, the adjuster must respect the findings of the IME. If the IME retained is not capable nor honorable, he or she should never be retained to conduct an IME. The agents in a case called Yunnan were held subject to liability for conspiracy to commit actual fraud, since they had a duty to abstain from injuring the plaintiff through express misrepresentation, independent of the insurer's implied covenant of good faith and fair dealing. But they were held not liable for constructive fraud in a case called Doctors Company versus the Superior Court, a 1989 decision of the California Supreme Court. It should be obvious that every adjuster must avoid personal liability. The adjuster must never enter into a conspiracy to defraud an insured. When an independent medical examiner's report is required, the adjuster should act so as to ensure that the report is scrupulously independent. or risk becoming a defendant paying extreme punitive damages for a conspiracy to defraud an insured. In Yunnan versus Equifax, a 1980 decision of the California Court of Appeal, the insured successfully claimed that the investigator adjuster conspired with an independent medical examiner to deprive the plaintiff of the benefits of his disability policy. The court believed the allegation that the investigator instructed the doctor what to find and what to write in his report. This was an obvious act in breach of the covenant of good faith and fair dealing. This video was adapted from my book, my newest book, Zalma on Insurance Claims, Part 107, 3rd edition, which is the 7th part of my 10-part treatise on insurance claims, and is available as a paperback, a Kindle book, and as a hardcover, all from Amazon.com. If you found this video to be interesting or useful to you or your colleagues, please pass it on. It's free. And please also subscribe to my YouTube channel, my Rumble channel, and click on the like button and the Rumble button when you view it. And also subscribe to my blog and to my Substack publications so you can learn of future videos and future blog postings. And on Substack, what will be some future very special publications for a very small fee. Thank you for your attention.